about to leave, already packing. Come with me, I'm not really asking. We'll get away to a place where we don't know. About to see the world in action, what we can be, life with no distractions. We'll get away, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts. Be free with me. Let's be free with Not looking back, eyes on the freeway, Bonnie and Clyde, a classic cliche. We're on the run, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out. Die with my own doubts.
Hi guys, welcome to our second Tutor to You Law Clinic. This one is for OCR Paper 2, so hopefully I can see quite a few people joining at the moment. Hopefully that's what you're here for. So OCR Paper 2, my name's Sarah and this is Rubina.
Hi.
And we're here to just take any general questions really. So this is designed as a student question and answer session. So any of those sort of last minute revision or paper 2 questions that you have, those burning questions that you might want to ask us, feel free to pop them in the chat. We'll try our best to get to as many as we can. Last week for paper 1 it was super busy, but we did try our best to answer as many as possible. So we will try and answer as many as we can. So just pop your questions in the chat.
Yep.
Do you
We've
want to
also
start
had
off
some
Rubina, with the
pre-questions
first
as well,
question?
haven't we? Yeah.
We have, yeah.
So we'll start with a live question first, just because it's come straight through. So thank you, Zara K, for your question already. So if there was a scenario for vicarious liability and it was found that the tortfeasor is an independent contractor, should you go through VL first and then conclude? I mean, yeah, Sarah will probably add to this as well, but yes, I would definitely still go through because you'll get your marks for working it out in the first place to go through there. So I'll definitely go through what that tort is in the first place, go through the test for employment to work out, and obviously then if they're not going to be liable, then you are correct there. We're going to have to go through negligence out. Well, you don't need to then go through negligence, but you could then suggest in your conclusion that it wouldn't be vicarious liability because they're not classed as an employee, therefore you would have to sue separately in negligence. But that's not a prerequisite. You don't need to then state that. It's showing whether it's VL or not, isn't it?
Remember, OCRs tend to be quite good in terms of putting the topic in the question, so they do normally direct what they want you to talk about. So just as Rubina said, you may believe it's negligence, but you wouldn't have to go through that if the question's asked for VL. Another important point, which I did see from one of the grade booster students had asked earlier, is even if part of the test fails, so even if part of VL fails, you would still go through all parts. Essentially, that's what you're doing for your 20 marks, isn't it? You're showing all your knowledge of VL for 8 marks and then your application for your 12 marks. Okay, I can just see another question there then from 5-star. If I write Occupiers Liability Act 57 for defendant 1 and 84 for defendant 2, but it was meant to be the opposite way around, would it affect my grade? That has actually come from an AQA student. Sorry, I've just read the end bit of that. We have just had a session on AQA, so neither myself or Rabina do teach AQA, so I wouldn't like to say for a certainty. Certainly under OCR, you could still get knowledge marks for obviously putting in your knowledge of the act, but you do need to apply it correctly in OCR. So if the defendant was a 1957 visitor and you were talking about a trespasser, you wouldn't get the marks there for OCR. But unfortunately, I don't teach AQA, so I wouldn't like to say for that one.
Yeah, I agree. I like the question from, I think it's a Vez there, Vez 7. Do you think Occupiers Liability essay will be on both 57 and 84, or can they come up on their own? We've had many discussions on this, haven't we, Sarah, with our students? And I would prepare for all three eventualities, really. So I'd prepare what if it's just a standard 57 question. The same if it's a standard 84 question, and then I would plan what if it just says occupiers liability and you are sort of picking things from both acts to discuss there depending on the nature of the question. So we know it is occupiers, the advanced information has given us that, but when we've prepared our students, we've done the exact same there, haven't we, Sarah? Gone through sort of three eventualities there and check the command. It might not just be all of 57, it might specifically want adults and children, which I know has come up in previous sort of specifications from OCR. So good question there, Vez, because I think some people do think it could just be sort of one potential essay there. I like that one.
And there's a question in from Eniola. In negligence, when establishing a duty of care, do you use Caparo test or Robinson? And do you need to explain the development of duty of care in a scenario question? So, of course, for negligence, we know that the latest development for duty of care is that case of Robinson. So that would be required. That's a 2018 case. Exam boards normally give a 2-year grace period on cases. So we are well within or well past even that grace period now. So we should be mentioning Robinson for duty of care. The Caparo test is not abolished, so we would still apply that if it was relevant. But the case of Robinson does say that we can establish a duty in one of 3 ways. So by previous statute, by pre-existing case, that duty of analogy, or if it's a novel or a new case, that is when we would bring in that historic Caparo test and go through the Caparo test. So they are still relevant, but what I would say is, because we know negligence is going to be a scenario question, as we already know the essay is going to be focused, the evaluation is going to be focused on occupiers, read the scenario and try and work out if you can establish a duty by an existing precedent or statute, then you wouldn't necessarily need to go through that Caparo test. It's only in those new novel situations where you haven't got an analogous situation that you would go through the Caparo test. So it does very much depend on the scenario facts there. I often say to students, if in doubt and you feel you've got the time, put both in. Any irrelevant information will just be ignored. So if you're unsure, maybe do both, but it's time dependent.
Yeah,
sorry,
definitely.
Ruby, did you have a point?
No, I was just agreeing with you, really. And the same with breach of duty. Often you get students listing every risk factor under the sun. And again, I would just focus on the risk factors that are relevant to the scenario. You don't have a lot of time. And often when we've done assessments with our students, write 4 or 5 pages on negligence, and it often ends up going over time. But if you just stick to what you need to for the risk factors, especially, and as Sarah said with the duty there, it should save you a little bit of time. There's a couple of questions, I think B and Hannah, I think we have covered it, but you might have just joined a little bit later. So B has asked for occupiers, can it be specific, i.e. children? Possibly, the doors are open, aren't they, as a result? It's occupiers, we know that, but you could potentially have a 20-mark question just on a couple of factors there. So yes, and Hannah's asked pretty much the same thing there. Under the old specification before your time, there was an adult and children for the marks there, so it could be something that could be a possibility. Somewhere higher up, I'm just trying to find it, so apologies.
I did
somebody
spot
asked
a good
about
one from Eniola, if it was the same one, Rabina, on section A, or a different question.
No, I think it was Deleg and Star. There, Simran. I've just seen it. So for the first bit, can you get away with only learning stats or Deleg? I mean, the
I would
advanced
say
information
no.
does say, the advanced information does say delegated legislation and statutory interpretations. I can understand why you probably think to only cover one, but you do not know the nature of that 8 and 12 mark question. And I wouldn't, you've already had 6 topics dropped to 2. So I really, really probably wouldn't advise just to focus on one, because if it is a terrible question that's really difficult to grasp, you have lost really easy marks there. So yeah, I don't know if you've got anything to add, Sarah, but we've not advised our students to do that, have we? We've said to still stick with the 2.
It is a question that a couple of my students have asked, because if you look at the past papers, it does look like it tends to link the AO1 and the AO3 question,
Yeah.
but OCR have said that doesn't need to happen.
No.
So OCR are free to put up sort of anything on those section A's. So I wouldn't risk it. I think, as Rabina said, they've already been really generous in being very prescriptive in the advanced information, that I think dropping any more topics would be a shame if a question came up that you didn't feel that you could answer on the day. So I would allow myself that option, and I would make sure that I revise both. And that's what I've been telling my students too.
Yeah, definitely.
A little bit further up, but Eniola did ask, for section A, can you still get 8 marks without cases? This was a question that was also asked last week on paper 1. In general, yes. Certainly for a paper 1, there are topic areas that don't require cases. But I would say for statutory interpretation in particular, but also for delegated legislation, you should be trying to include some examples or some cases to get into that excellent bracket. Again, I've been advising to my students that in order to show your excellent knowledge, you should back that up with case law, particularly for statutory interpretation, but also where relevant for Del.
Yeah, I think if you had a question like golden rule and you couldn't show any case examples, I think you wouldn't be able to give it anywhere near the sort of higher levels, would you, as a result there?
And previously on mark schemes, they have listed cases for those.
They have.
So again, it's expected that you put those cases in.
Definitely. B, another cracking one there. Is it possible to get a 20 marker on remedies or defences on their own? I mean, there's enough content. I know we've not seen it yet, but you know, you're only the second year to go through it, really. First year on the new 20 markers. So I would possibly say so. Obviously, we can't say for definite, but there's definitely enough content there. If there was a couple of defences in there and some remedies, often they do come at the end of 20 mark scenarios. It might say, and what remedies can be claimed, and what defences could be applied here, you know, if there's a warning notice or some contributory negligence. But we definitely would suggest to have a look at potentially looking at defences and remedies on their own, but as well as another question such as negligence, and putting something like that on the end, yes.
Emma's asked just a general point of, will this live stream be available? Had we have had Jim at the start, Jim does a much better introduction than myself. He normally does say that, yes, they will be available. We always make live streams available after the event as well. So you can just find them on the same link, but by clicking replay. So that will be available. Victorious has asked a question there. How do you know what test to use for Vicarious? Again, this is a typical one I often get from my students, because as we know, we've got the older traditional tests, the salmon tests, and then we've also got the akin to employment, haven't we? The sort of new approach coming from cases such as Lister and the Catholic Brothers case. So what I would normally say to my students is, again, read the scenario. Similar to my answer for negligence earlier, Vicarious, we know, will be a scenario question. So read the scenario and determine what test you think applies. At least one of the tests need to apply for the person to be classed as an employee. And again, if you've got the time, and I do think with vicarious liability, you may have a little bit more time than negligence. There's less content to put in for your AO1, maybe put in multiple tests. So for my students, I do usually say, you know, if the control test is passed, maybe look at one of the others and see if that's also passed. And that way, again, you're showing your excellent knowledge that you can apply more than one test. So definitely at least try and apply one test. And often look in the scenario as well. Sometimes it's written in a way that's very similar to cases that you might have studied. So if it's something like somebody committed a sexual offence and that's the tort, then again, think about them newer cases under that akin to employment test that's the non-traditional approach.
Definitely. And with the sort of second element of that as well, looking at in the course of employment, not in the course of employment, hopefully the scenario should sort of guide you as to, is it a frolic? Is it something that's authorised? And again, in your AO1, discuss the ones that are relevant. Don't think that you do need to talk about every single within the course of employment and not within the course of employment. I would really focus it on there. I don't know who it was, but higher up in the chat, there was a really good question asking, how do we know in negligence what way the duty is owed? And when would we use Caparo? Now, we've said this a lot to our students because they do get confused with Caparo, don't they? Now, Caparo is only if it's a novel situation. And I mean, novel situation is in a brand new potential duty. So if you've got, a car crash, well, a car crash isn't brand new. We know that people owe duties to each other that's on the road. And the same if it's sort of a doctor situation, they've given you a wrong news. Otherwise, you're not meant to know. You can't be taught every single potential duty situation there. So what I would do is probably a process of elimination. So I would have a look and think, right, do I think that there'll be an Act of Parliament on this potential area? Or do I think there could be a case law on this area? And there might be two, that you might potentially be able to use both. And if I don't think there's an act or there's a case already on it, and it's sort of alluding that it might be new, it might tell you it's not been decided before, then I would suggest to look at Caparo. But Caparo is really, really novel now. It should be used very, very rarely after, obviously, Robinson's gone to court. So it should really make it a little bit clear to you in the sort of scenario text if it's something that's never been dealt with. So I think the last time they did it was a drone, wasn't it, Sarah? And they said at
Charlie
the
and
end,
the Drone
this
in
was novel.
2019.
Yeah. Yeah, so they said in the last bit of the command, there's no existing precedent on this. There's no law. So sort of helping students to show that Caparo would be the preferred route there. As Sarah said, if in doubt, you can still discuss it anyway, but it is better to go down that route of statute precedent, reason by analogy, or Caparo if it is something that's brand new. So I hope that's helped.
Yeah. We do have a question there from Casey. And also Duncan, if you don't mind, Duncan's just in the background doing all our tech for us today. Putting up slide, I think it's slide 4.
Do you have to put cases in 12 markers for section?
Oh, slide 3. Sorry, Duncan, slide 3. So the question is, do you have to put cases in a 12 marker? And again, the answer there really is no, not necessarily. We're just on the next slide on Duncan, I think. Yeah, that's the right one. Not necessarily, but you could use cases to support. So I often say to my students, if you are struggling to develop or well develop your point, cases can help to support the evaluation, but they're not necessarily needed because a 12-mark evaluation is only looking at that AO3 skill, that evaluation skill. So this is the structure that we tend to tell our students, myself and Rabina, is to make your point, make your evaluative statement, discuss whether it's an advantage or a disadvantage with reasoning. Again, you could bring a case in there if you felt that it supported that. If you're discussing something on occupier's liability, if it is children, for instance, and you want to use a case such as that Glasgow Corporation and Taylor, then use it. But you're using it in a very different way than your AO1. So you're not just explaining the case and explaining the principle of the case, but you're using it to back up your evaluation to state whether you think that there is a current issue with the law or whether the current law is satisfactory or whatever the question asks for. Similarly, when you're well developing your point, you can use a case to provide a little bit of a further analysis. So if you have said, if it's a 1957 evaluation, you have said that the law is satisfactory because it looks at children with a different level of duty, occupiers owe more duty towards children, then you could use that case of Taylor or any other child case in your well-developed point to support that. So in fact, I've realised I've been talking about 20-mark evaluation at the same time there, but same process for both. Yeah. Obviously, for 12-mark, it would be Del, Leg or Stat, wouldn't it?
Yeah, definitely.
Cross topic slightly.
No, but as you say, Sarah, the skills are exactly the same because the 12 marks from the evaluation are the exact awarded the exact same as the 12 marks from the lawmaking side. So using that skill and that structure, as Sarah's bobbed on there, is a really, really good way to be able to get those marks there. And if appropriate, using cases, yes, but obviously not always necessary as a result.
Again, with statutory interpretation, because most of your knowledge will be case-based, again, absolutely use them cases to develop or well develop your point in your evaluation for a 12 marker.
Definitely. Vez has put in, for Rylands and Fletcher, do I have to include cases for both natural and non-natural things brought onto land? No, not really, Vez. What you have to remember is that in order to gain that excellent band, what is suggested is, a wide range of cases. There's no guidance as to how many. We normally teach our students sort of around 4 cases. So as long as you've got an excellent description of Rylands and Fletcher, you've gone through the parts that need to be established. The case that you use could be a natural use or it could be a non-natural use of land. It is entirely up to you what case you do want to use to back yourself up. As long as you know what non-natural use of land is to then apply it to the scenario question, that's absolutely fine. So as long as you've got a range of cases within the text that you are going to obviously use for your AO1 there, you're absolutely fine.
And again, that was something that was asked on paper 1 as well. So it's a common theme. You don't necessarily need a case for every area of law. But again, it does help to explain that topic often or that area of the test.
Yeah.
There's a question from Emily, and there's been a few questions on this about vicarious liability, and again, whether to go through all of the tests or not. The past mark schemes haven't been very clear on this. So I know me and Rabina have had this discussion ourselves, and we certainly usually say to our students, if there's time, do include all of the tests to show that AO1 knowledge. But again, it is about applying what's relevant. So there's no point just knowledge dumping absolutely everything that you know. Read the scenario. If it's obvious that there is a particular test, again, if you're dealing with whether the person is an employee or not, and it's very clear that it's the new approach, the Akin to Employment approach, then it would be fine to apply that one. But if in doubt, I normally say to my students, and if you feel you've got the time for that, do put all parts of the test down. I know that's not very clear, but I do feel like the past mark schemes haven't been overly clear on this either.
No.
So again, if it's something really obvious in the scenario, don't include irrelevant information. If you're unsure and you feel you've got the time, put it in.
Yeah, definitely. And like you say, that's what we've said to our students before. It's, if you're never 100%, it's better to go over, isn't it, than obviously go a little bit less and see there. I know there's been a question in there about the November 2021 topics for the Section A. They were obviously on statutory interpretation and the lawmaking booklet, the legislative process, but obviously be aware of your advanced information. So you do know that you will get statutory interpretation and delegated legislation on there. And as we've advised already, I wouldn't focus more on one than the other just because of the nature of the style of questions there, because they don't have to match. So I think it's important for you to make sure that you are focused on both, as you have already had it dropped from 6 to 2. And it is obviously quite a big part of the paper with the marks there as well.
And also remember, just because something's came up in November doesn't mean it's off the table to come up again. We often say with tort, there's less areas in tort, isn't there? So with criminal law, there's much more topics. In tort law, we're quite restricted for topics. So revise everything. Don't just rely on sort of narrowing down. As we've already said, the advanced information has already done that somewhat for you.
Yeah.
Anisha,
we can't really answer that one. We're not marking that paper. Sorry.
But either way, as well, I did have quite a few students asking this. I think
we've had it, haven't we?
Question command, but we would wait and see what was on the mark scheme. But ultimately, don't worry, you've done that paper now, it's out of the way, so focus, as you're doing most likely now, focus on paper 2, focus on paper 3. Remember, your grade comes from all 3 papers together and they are equal weighting, so I wouldn't worry too much about what you wrote on paper 1, it's in the past, so focus on the next 2. Eniola has asked another great question there. How much do you explain the case, and can you write a level 4 response by bracketing a case? Again, I'm talking as a teacher here from my own personal view, what I would tell students. I do personally tell students to not include the facts. Maybe you might refer to the facts in the principle, so you might end up mentioning some of the facts, but I don't want a story. I don't want you to tell me about the case or tell me what happened. The main outcome is what was the principle of that case. So I would be expecting for an excellent response for the principle of the case. And you could bracket the case if you've outlined the law and that's the same as the principle, if that makes sense. So if I'm using Robinson and I say that a duty of care can be established in one of 3 ways and I explain those ways, then I could bracket Robinson at the end because I know that's where it's come from. But I would avoid just bracketing cases. I would try and put some kind of principle or explanation with it, but not necessarily a story of the facts.
Yeah, definitely. We usually say about a sentence at the most, don't we? Because otherwise you end up with about 4 or 5 lines as a result there.
The other point on that as well is to try and make the case distinguishable. I often
Yeah.
have responses where it might just say was liable in negligence, full stop. It's not really telling me very much about the case. So tell me why, include the principle of the case. And you may find that you put a couple of facts in there, but that does help distinguish what case you're talking about. That also really helps if you forget the case name. So I have had that on occasion where I've been marking my own students' work and I can clearly see what case they're talking about, but they've forgotten the name or they've got the name wrong, and I can see their niche has asked that question. Ideally we would remember the names, but if you can't, we understand it's a pressurous situation. If you make that case distinguishable and it stands out, it should still be credited. Again, as long as you're not doing it consistently all the time with every case. If it's the odd case, examiners tend to give benefit of the doubt for those.
Yeah. Zara Kay's asked about reforms. You in terms of the reform, you can make your own suggestions for reforms there. It doesn't have to just be any sort of particular things that have been suggested before. But we've had the main one for occupiers has been sort of compensation schemes, hasn't it, Sarah, as a result. But if there's something particular that's pressing that you would change, then I would definitely bob that down in your conclusion as well.
The Pearson Commission as well, I often tell my students, I believe it was 1975, suggested that we go to a system like Australia have, where we don't actually sue one another for torts. We have sort of a money pot from the government, paid for through taxes, particularly for those like road traffic accidents, where you would claim directly from the government rather than suing somebody. So the Pearson Commission 1975 could be a precise reform if you're looking for one. Obviously, we haven't taken that on board. It's not something we do in the UK, but it's something they do in Australia. I'm just catching up with the chat, sorry.
I know. There's a few on there, isn't there?
Simran asked a great question there, and again, one that my own students have asked. As the evaluation question is occupiers liability, could it be a scenario? My answer to that would be yes. I would say, again, don't try and necessarily narrow down questions even more than we've been given already. You could, for instance, have a 1957 evaluation and a 1984 scenario. Or you could have both. It's up to OCR what's on that paper, so I would prepare for both.
Yeah, brilliant. Hugo, no is the short answer to that one. You just need to be able to know what we do in terms of special and general damages when you're looking at remedies that victims are going to try and claim. It's Pearson, Zara, so it's Pearson, Pearson Committee.
And then we have the question just above Zara's. Do we have to revise extrinsic and intrinsic aids for AO3 and AO1? There's not much we can talk about. But again, it is on that advanced information, isn't it? It comes under statutory interpretation. So again, yes is the answer to that. Make sure that you include those as well. You should be able to include examples, so similar to what we were talking about earlier, whether that be case examples or situations where those intrinsic and extrinsic aids have been used. So, for instance, an extrinsic aid would be a dictionary, and a dictionary was used in the Cheeseman case. If you've studied that case, obviously refer to cases that you may have studied already on your course.
Yeah. Definitely. And in terms of evaluation, because I know you mean there about there's not a lot, but you can evaluate specific aids as well. So if it is just a general, advantages or disadvantages of intrinsic, you could do a general point as to why it is good or bad that we have got these intrinsic or internal aids to support judges, but also you can pick on specific ones. So even things like preambles, we don't tend to have them now for more modern acts. So why could that be a disadvantage in compared to when we did have, and same for extrinsic as well. So if you are struggling for some form of evaluation, I would pick on sort of specific ones as well, rather than just looking at sort of the general situation of having an intrinsic or an extrinsic aid there.
And then we are coming towards the end, so we may take a couple more questions, but I just thought we had a little bit of a true or false game pre-prepared if we wanted to pop that up, Duncan, please. And this could hopefully help answer some more questions. So feel free to join along, guys. You can just put a T or an F into the chat. So I'll take the first point, which is you need to include section numbers and the year for Acts of Parliament. We had a few grade booster students ask this question, actually. So just in the chat, if you want to play along, guys, what do you think? Is that true? You do need to include section numbers and the year for an Act of Parliament, such as the Occupiers Liability Act, or would you think that was false? You think that you wouldn't need to include those?
So we've got a couple coming in here at the minute. Yeah, Duncan, do you want to go through and
that one is, of course, true.
Yeah,
you don't need dates for cases, but you do need dates for your Acts of Parliament. So you do need to know the OLA's 57 and 84, and section numbers would also help show that excellent knowledge. If we have another one. Occupiers liability is the focus for the evaluation this year on section B. Hopefully we would know that. We've discussed that a little bit already in the chat.
Hopefully nice and easy for you there, guys.
And the correct answer, of course, is true.
Yep.
I am trying to pick up on a question that's coming by Hannah. Do you need an introduction and a conclusion for a 12 marker? No, you don't, Hannah. So you do need those on the 20 markers. Or certainly a conclusion on the 20 marker, you need to answer the question. But on a 12 marker, you don't need an introduction and conclusion. Bina, do you want to take this one?
Yeah, so question number 3 then, you need to answer all questions on the section A on the lawmaking side. So if you can just put true or false in there for me. So true or false, there's a couple coming in there. Milo, the evaluation question is part of part 1 or part 2 on the tort side. So it's the final 20 mark question that you'll do. So we just have the section A and then we just have part 1 and part 2. If we just have the answer then, please. Duncan, we've got a few coming in here. Excellent. You know, you guys are ready for next week. So you don't answer all 4 questions, do you? You choose 1 8-mark question and 1 12-mark question, and you can choose. They don't need to match the AO1 and the AO3 that you have done, and they might not necessarily do that anyway. But yes, you choose 1 8-marker and 1 12-marker. And then the last question then for the true or false, so you must include case facts and dates when you are referring to case law. So again, Sarah's already picked up on this point. So do we have to include facts and dates of the cases when we are discussing them? Hannah's straight in there. Yeah, fantastic. If you want to finish that one for me, yes, it is false. As we say, at the most, if you are doing facts, we usually say a sentence. At least then, if there is a spelling error or a case that's incorrect, we can give some credit. But definitely not for years. The years are just important for your Acts of Parliament because that does count then as statutory reference. So you do get credited then as if the Act was a case. So it does help you get into your excellent mark band there as a result. Brilliant.
And if we could just finish on that first slide, please, Duncan, whether we need to answer all questions on the paper, because, again, we've had this question a couple of times from grade booster students, and it is one of those that sometimes in the panic of an exam, people do just sometimes get mixed up or forget. So I would just want to sort of remind everybody, really, that on section A, remember, you do have a choice. So you do only have to answer 1 8-mark question on section A and 1 12-mark question on section A. Section A, as you can see there, is worth less marks on the paper. It's worth 20 marks in total, but that is only 25% of the overall paper. Section B, as we know, is the meatier side. It's one where we're picking up the most marks, 60 marks or 75% of the paper. Again, on section B, there is a choice, but commit to the side that you pick. So if you go for side 1, make sure you answer all 3 questions on there, and same with side 2. Every year, I'm sure there are students who don't follow the structure. It does also explain the structure on your guidance on the start of the exam paper, so if in doubt, do refer back to that. The issue, of course, is if you pick questions off both sides, you're not going to get full credit for those questions, so do commit to a side and answer all 3. The evaluation won't change. The evaluation will be the same on both sides, so I often say to my students, start with that. I'm sure you've been preparing for occupiers liability as a evaluation question. So perhaps you could start with that one. You can answer in any order. So again, play to your strengths. I actually normally tell my students to finish on the 8 marker. And
Yeah.
that means that if you are running out of time, you've managed to answer the big questions first as well.
Yeah, definitely. I think that's always the better option there. And just to reiterate what Sarah said about choosing the entire side, because it is disheartening when a student comes out, tells you that they've done one from each side, and you know already that means they've lost 20 marks instantly, because you can't pick and choose there as a result. We just had one final question at the bottom. Obviously, I don't know in terms of AQA law, because we are OCR specialists, Sarah and I. So far, they have stuck to the advanced information. I think you just need to read what the advanced information is giving you. Is it guidance of a focus, or is it really telling you what a potential question is going to be there as a result? But yes, we can't really go any further into that just because we're not AQA specialists.
But thanks, guys. It's been a very nice, busy session there. Lots of questions coming in as well. I didn't quite get onto all the previous grade booster questions, but we answered a good range of questions there. We are also doing the same session next week for human rights and contract law, and of course nature of law, so for paper 3, just in time for that paper 3 exam. So if you have any questions, you can direct us or to us then.
Yeah,
but thank
and if
you
you
for
haven't done
that, guys.
Yeah, and if you haven't done so yet, if you are signed up to the Grade Booster, obviously there's a lot of resources on there and practice questions and activities. So if not, have a look and see if you can do. And obviously a lot of the live revision blasts we've done this year are on there as well. So there's plenty for you to be doing for revision. And best of luck for Paper 2 next week.
And just to reiterate what Rubina said there, for this paper, there are lots of revision blasts available on the free part of the website as well. So if you are a grade booster student, there's lots and lots on there. But if you are not a grade booster student, but you'd still like some extra tutor to your resources, if you follow the link that you've gone for today, but click on replays, there is revision blasts for all of tort law on there to keep you busy. But good luck for next week, guys.
Yeah. See you later.
Thank you. Bye.